Hello and welcome to the first CLE of 2023 in the drug court. Thank you for your attendance. I am your CLE coordinator, Kathy Anderson. This lecture has been approved for 1.5 hours of CLE credit by the Tennessee Commission on CLEs. Also, our presenters here today would like for you to ask your questions at the end of the presentation versus asking them as they arise. Now, today's speakers, we have the Honorable Lee Wilson. Welcome to the class. As you all know, Judge Wilson was elected by a landslide back this past August. And he was originally appointed in 2010 when he was in General Sessions 10, right? Very good. And he was before then with Stokes, Wilson, and Wright Attorneys at Law from 1993 to 2009. What some people don't know is that Judge Wilson was a part-time divorce referee from 2004 to 2009, Assistant District Attorney General from 1986 to 1993, and Assistant Public Defender back in 1986. Worked for the city of Memphis from 1983 to 1986. He's worked with everybody in the criminal justice system. He hailed from the University of Pittsburgh School of Law and Morehouse College. We also have here on our panel Assistant District Attorney Marguerite Kello, who's the lead Attorney General in the drug court at this time. She's been there from 2019 to the present. She graduated undergraduate from the University of Houston in finance, law school, Texas Southern University, and she came to us here in Shelby County from the Galveston County District Attorney General's office back in 1996. And she's been with the Shelby County Attorney General's office since 1996. We have Attorney Eric L. Acrobats turning backflips down the aisle. Picture it in your mind. Eric is the supervising public defender in Division 8, the drug court. Eric has been with them since the drug court?
Probably about 3 or 4.
Yeah, it's been eons. And Eric went to undergrad at Rhodes College and got his JD from the University of Memphis, a true homegrown boy. Now, our CLE is going to last for 1.5 hours of instruction, and I am going to start the CLE timer right now. Thank you all for coming.
First, I'd like to say good afternoon. I was looking around the room, and it seems that I know probably about 99% of the people that are in here. When Ms. Anderson was introducing me, she made it seem like I was real old. She talked about back in the 80s, but I just want you to know when I was practicing back in the 80s, I was just a mere child back then. So I'm really not that old as you may think. But I have been around for a while. As she indicated, I was elected back in August of last year. And as most of you are aware, that we had only had one judge in our drug court since 1997, which was Judge Tim Dwyer. The program was started under him. And I thought it would be a good idea, since I was taking over, to come and just kind of present to you our vision for the court, I should say my vision of where we're going with the court. Judge Dwight did an excellent job in starting our drug court. As you may be aware, there are over 3,000 graduates of this program to date. And we would like to think that it's probably the best program in terms of rehabilitation, in terms of criminal rehabilitation programs in the country. Only about 25% of our graduates reoffend after 5 years. And as you know, that's almost unheard of, more like 75% for other programs. I know when I was in private practice, you know, there was always some mystery about drug court and exactly what was going to happen when you put somebody in drug court, or even when you were thinking about making an application for one of your clients to drug court. It was always kind of like a mystery to people on the outside. And so I thought about it. I said it would be a good idea just to come and talk to you about how to go into drug, what happens in drug court. Because if you ask the average lawyer, they have no idea. They might sign up somebody, you know, bring them in, sign them up. They have no idea what happens to their clients after that. And so, but to me, it was always just kind of mysterious about what was going on. So I said one of the things that we wanted to do is come and just talk to you about the drug court, and hopefully at the end of this seminar, that number one, you will feel comfortable with putting your people in the drug court, feel comfortable with the program, because that's another thing. Lawyers also thought that when they put their clients in drug court, they would somehow set them up for failure. Like the program was going to be too difficult, and they were going to wind up in jail, and they were going to do a lot of time. And so they were also reluctant to put people in drug court for those reasons. But, you know, that's really not the case, at least now that I'm here. We, number one, we're all about rehabilitating those who really want to be rehabilitated. You know, once you apply somebody for drug court, and they are taken into the program, or they're admitted to the program, it's no longer about punishment, but it's about rehabilitation and what we can do to, number one, make sure that person can complete the program. Because we don't want people coming into the program and not being able to complete it. If we can help it, of course, you know, ultimately, it's always on the client as to whether they can complete it or not. But we are not, it's not a program in terms of when you put your clients in, though, one that we're going to abuse them. I know there was something else about it would be so difficult that they would be, you know, somehow abused in the program. None of that is true. But before we go any further, I just want to give you a couple of statistics about our program. Like last year, the court admitted 126 participants. Of those 126, 46% of them were white, 47% of them were black, and 7% was other. Half of those admitted to our program are heroin or opioid addicted, and 26% of those are meth addicted. And right now, our graduation rate is 56%. Of course, we'd like to see that a lot higher. We have, you know, I am not going to be so quick, let me just say that, to terminate people who are admitted into our program. We're going to try to do everything that we can to see that they're not terminated. But of course, you know, those of you who practice criminal law know that sometimes, regardless of our best efforts, the jail seems to be the end of the line. But that's not where we want to start, and that's not where we want to end. So, with that being said, you know, I'll just turn it over to, I guess, Eric, you're gonna start, You know, Eric has been in this court a long time, I think since 2003. So he was here for the bulk of the time with Judge Brown, but he knows everything about putting a person in drug court. And he is one of the public defenders who practices in there. And actually, when private lawyers put their clients in the drug court, most of them just turn them over to the public defender's office while they're in the program, and let the public defender's office kind of take care of the representation while they're in the program. So in our staffing meetings, Eric is actually a part of our staffing meetings. When we were discussing the defendants, he's right there as well, you know, giving his advice on what we should do with clients as well. So there's always a lawyer involved in this process, even though I don't know if you ever thought about it, that once your client was in drug court, that they were just at the mercy of the judge. But that's not true. They'll get a hearing on anything that requires one. They will get a hearing. So I want you all to keep that in mind as well. Don't think if somebody is automatically terminated, that I'm going to give them the max and it's over. That's not true. I said for a sentencing hearing, just like anything else, and I'll hear proof on it and make a determination on a case-by-case basis as to what that sentence should be. So I think that's another thing that a lot of lawyers have a misconception about, is that if they are violated or terminated, that they would automatically receive the maximum. And I believe in taking it on a case-by-case basis in terms of terminating. Number one, it's my ultimate decision whether anybody is terminated, and it's also my decision on a case-by-case basis what that sentence would be if they are terminated. But go ahead, Aaron.
Thank you, Judge. And I know Kathy said that we will take questions at the end. I don't care if y'all interrupt me with questions. If you have any, please do. I'm just going to talk a little bit right now about kind of the process for getting someone into drug court and what kind of case you might want to consider for drug court. If you've looked at your handout, there's also a little bit of case law in it. I'm going to discuss that once everyone is done. I'm going to fill the remaining moments up with discussion of case law. So everyone stay awake for that exciting teaser. That'll be at the end. I like to say when we're talking about what kind of case, should be considered for drug court, there's kind of a sweet spot as far as cases go that are really good cases for drug court. You don't want something that's too minor. If you can, obviously, and I know there's some young attorneys in here, but everybody probably knows, and this goes without saying, if there's any way to get the prosecutors to null cross the case with conditions, or maybe not with conditions, but any way to get a case null cross, very few clients would turn that down. I think that probably is your first priority when you're trying to settle a case, if you're going to settle it. If there's a way to null cross the case with community service, with donation, with some drug classes, obviously that would be I think your first priority. So, the default shouldn't be, well, we're going to put someone in drug court. You need to weigh the case and figure out, is this something I can settle in another manner that is going to be, less onerous for the client? And you got to just take your client's wishes into consideration. The two best features of the drug court program as far as our clients and our cases go are, one, it gets your client help with whatever problems they're having as far as drugs or substance abuse. But the other big one, obviously, is that if the client graduates from drug court, the case comes off the record. So those are the two kind of guiding priorities that we should be seeking when we're putting a client in drug court. If you you have a client that's in criminal court, obviously, if you put someone in drug court as a condition of their criminal court probation, the case is not going to come off the record. So we have a lot of new judges, and several judges will agree to this. If you could work it out with your prosecutor to keep the case open for 12 to 18 months and allow the drug court to provide the treatment and provide progress reports to your judge, then if the state will agree to not process the case, obviously that's a way to kind of utilize the drug court, get your case off the record feature in criminal court. I know Judge Poole's doing that with a bunch of our cases right now. Like I said, there are a bunch of new judges, and I think there'll be several of them who are open to that if the prosecutor is on board with it. Another problem as far as cases go that we have are DUIs. Of course, the DUI statute is one of the most draconian in the United States. But you cannot divert a DUI, and you can't put a DUI through drug court and get it off your record. I kind of discourage people from putting DUIs in the drug court just from a legal standpoint, unless it's going to achieve some sort of reduction, like from the third or second to a first, certainly from maybe a felony to a first or second. If that is on the table, if that's something you could negotiate, then drug court's great. A great option, but DUI is not going to come off your record, off your client's record, if you put a DUI in drug court. If you can get it reduced to reckless, of course that would come off the record. That would be a great option, but you kind of got to be careful with DUIs. I'm always free to talk to anybody who wants to talk to me about whether or not I think a case is a good case for drug court. I think most people have my phone number. You can always find me. I'm usually in either 8 or 6. Let's see what else I got here. This should really be something that is your client's. It should always be something that is your client's choice, whether or not the case is going to come to drug court. Lots of clients, will have a drug court offer, and we have a lot of clients reject drug court offers, especially if they already have a record, a substantial record, and they're not too concerned about having something else on their record, and the offer is probation. If it's even sometimes if it's a short correctional center offer, or certainly if it's a time served offer, we have a lot of clients who say, I'm not interested in drug court. And if they're not ready, they're not ready. And if it's not a priority to keep a clean record, and they don't want to go through 12 to 18 months of very difficult work, good work that's going to, help you, but a lot of work, at the end of the day, it's a lot of work, then, clearly a lot of clients are going to choose not to do drug court. You need to have a client who seems at least a little bit open-minded to engaging with the treatment concept, with the treatment team. You never really know who's ready to stop using drugs. You never really know who is hit what they call rock bottom. As very relevant to the person's situation is just a very relative term. But if your client is wanting help, if they want to keep something off their record, drug court might be a good option for that client. And I want to echo kind of what Judge Wilson said a moment ago. For those of you who have been very reluctant about putting somebody in drug court, about entertaining the notion of using drug court as an option for your clients, I want to personally tell you, I'm here to tell you, one of the reasons I'm here at this CLE presenting, and one of the reasons I think we're having it, is to say that Judge Wilson is very fair. He does not default to jail as the first sanction for an infraction, for a Judge Wilson is very open to therapeutic sanctions. He's open to counseling, additional counseling. He's open to extra support group meetings. He's open to community service. He's open to a lot of things with jail being the last resort as a sanction. And if you've been hesitant over the years because you are concerned that your client's going to be locked up unfairly, repeatedly, I think that I'll just say that Judge Wilson is a very fair judge. And another thing Judge Wilson alluded to, in the unlikely and unfortunate event that your client does get terminated from the program, there is no default to 1129 to serve. There's no 70% if they're a runner. You know, these old ways of, you know, predetermined attempts at predetermined sentencing is gone. Judge Wilson will give you a fair sentencing hearing and listen to mitigating evidence. What else? Let's see. Just to the private attorneys, Judge Wilson alluded to this as well. Judge Wilson is now appointing the public defender to all private attorneys' clients who go into drug court once they start drug court, if the private attorney wants that. So we're here to advocate for your client. We will speak up for them. Tucker, Chris, Sandra, and I are currently the ones who attend drug court staffing. You know, sometimes I'm the only one at the table advocating a certain position. Sometimes I can get people behind me, and sometimes I can change minds, and sometimes, you know, I can't, but I will do everything I can. And I just want you to feel, I think I'm trying to express that the drug court may be a little more welcoming and just we have a very fair judge. I'll leave it at that. Who's next?
Hello, everyone. I believe everyone knows who I am. I'm Margaret Kello, and I recognize, I think, about 95% of the faces, and I'm glad everyone came. And I'm going to echo a lot of what Eric Elms has said, is this is a really good court, and we have a great drug treatment program. We have a great judge who's very, very fair, and if I must iterate anything, is that the drug treatment program is not a program to punish defendants. It is a program to get assistance and help for defendants who have drug problems, particularly fentanyl, meth, cocaine. And I would say this from my experience. I've been here 26 years, and before I was assigned to drug court, I would do an average of order an average of 2 death certificates a year. 1, 2 a year. Since I have been assigned to drug court, General Sessions 8, I've done an average of 3 a month. People are dying from fentanyl. We have a drug problem in Shelby County, and I'm not saying everyone qualifies for the drug treatment program, but the program is here for those who need it, desire it, and we have a great staff of defenders. Eric is great. I see him working at this every day, talking to his clients, encouraging them into the program. You always want to have those that say, no, I don't want it. I don't want it. It's not for me. I can kick the habit myself, or I'm online doing a treatment program. But there's nothing like participating in a program day to day. For some people, it does seem to be a relatively long program. 18 months is a long time, especially if you are 25 years old. That seems like a very long time. But if you're able to make it through the program, as Eric says, the case is dismissed. There are some exceptions, such as DUI, if it's a case from criminal court. Of course, there are exceptions. But the goal is to help defendants get off the drug problem, particularly in my opinion, what hurts me when I see young women who have children. They're able to be reunited with their children. And you're talking about a success story, it is absolutely, when you come through graduation, it just warms your heart when you see the people make it through the program. I've been in Division 8 long enough that I've seen people from start to end. As far as the process, when an individual is charged and the case lands in criminal court, during Session 8, if a private attorney, one of the members of the Public Defender's Office, wants the person to be in the drug treatment program, they would come to Paul Hagerman, who is over the unit. It's the narcotics gang unit, and ask that the case be considered to be assessed for drug court. All of us in the unit can do that, but Paul is our head person. If he's not available, then just kind of go through the chain of command. Once Paul Hagerman decides that yes, the person is okay to be assessed for drug treatment program, then it would go to one of the drug court counselors. One is on the panel today. I believe there's 10 drug court counselors.
10 staff.
10 staff. And I must say, these are some of the hardest working people that in the building. They will, one of the things they will ask me is for an NCIC, and I'm sure most of everybody knows what NCIC is, and they will take that information and they will interview the defendant and make a determination whether or not that person is a good candidate for drug court, and they will give that information to the attorney, whether it's somebody with the Public Defender's Office or a private attorney. There are certain charges that are disqualifying, such as rapes, murders, arsons. I think most of us can pretty much figure that out. Pretty much all robberies, ag assaults, domestic violence involving a weapon.
Violent felonies.
They're going to be disqualifying.
It's in the law about misdemeanor domestic violence assaults that the managers can talk about.
We would also consider defendants who are in other divisions, other general sessions divisions, criminal court division, as well as municipalities in Shelby County, Germantown, Bartlett, Milton, so but Shelby County. So if you have a client that's in Bartlett, it kind of has to jump through a few hoops just a little bit to get the case here. But once it's here, and it's on the docket, we still go through the same evaluation. It has to be approved by Paul Hagerman. And that's based on looking at the charge in Shelby County. Then we will get NCIC, and then the council will review that, and then we go forward. As the Judge Wilson had mentioned earlier, that Shelby County does have one of the best success rates in the state of Tennessee. And I think we all, at the end of the day, do a good job. If I must toot my own horn. I know at the end, if anyone has any questions, we will answer those questions. And I must say, the drug court counselors, I see them every day. They are hardworking. If you don't want to ask me or ask somebody at the Public Defender's table, you can pull them to the side and say, "Can I ask you a question?" And they're more than helpful to answer your question without you getting into the facts of your client's situation. I haven't seen them like, "I don't have time." Oh, he's not on the docket. That's not how we do it in Division 8. Again, at the end, if you all have any questions, we will answer those questions. The bonus of going through the drug treatment program, with some exceptions, is that if your client is successful, the case will be dismissed. And a bonus is that the case will be expunged. And I think that's the goal. Once a defendant realizes that, that's something to achieve. Because I see the graduation, I see their families, and they're there for them to support them. And that is absolutely an accomplishment for someone to go through, not be arrested, on the program. And in addition, if they're not rearrested, and they're successful, the program is still here for them. So they finish this month, and they say May they're getting weak or tempted. As long as they're not rearrested, the drug treatment program is still available for them. It just, we don't close the door on them anymore.
Can I just add one thing to what Margaret said? If your prosecutor in your division makes you a drug court offer, like Marguerite said, the drug court policy is that someone from the division 6, 8 team, one of their prosecutors does need to approve the offer. And as far as the public defenders here, if you don't have time to go talk to the prosecutors in 6, you can always give me, if you can get your state's file, you can give it to me, and I'll be happy to talk to them about it. I know it's onerous to get an offer and then have to go get an offer from another prosecutor. So, for all the public defenders, I'm just a phone call away. I can talk to the AGs in our silo about your case. If you need me to, I can relay what the drug court is saying they need. If you don't have time to come down, I can help you with your paperwork. So can Tucker and Chris and LaTanya, who's here on Tuesdays and Fridays. And every other Thursday she's in Division 8. So, yeah, just please feel free to call me to help you with any of that stuff.
All right. Hello, I'm Angela Parkerson. For those of you who don't know me, I'm the court administrator for drug court. And I'm going to talk about, there is one other way your client can get referred to drug court other than getting the approval from Hagerman's team. Occasionally, a judge will refer a client to drug court, and if that's the case, you can bring it directly to Judge Wilson and say, Judge Poole referred this case, and then Marguerite will start the process, and eventually Marguerite will run the NCICO one if there's not already in one. That is another way that we get referrals from drug court. So now you have a drug court offer. What you're going to do is bring your client into Division 8. And you're going to bring the file in and say you're going to come to the counselor table, which is, you walk in the courtroom, it's to the left. Eric and his crew will be at the other table. So you'll come to the counselor table with the file and say, I have a drug court offer. So they are going to tell you to sit your client down in the back so we can interview them. So we're going to interview them, ask them a series of questions about their, first of all, their address. We're going to get collateral contacts. We're going to ask about their use history, ask the criminal history, what they think their criminal history is, and discuss the program with them. We're going to tell them in general, which I'll get to in a minute, what the program involves. Then we're going to go ahead and set them up for an assessment, whether if they're in custody, Ms. Fisher, who is our clinician that does our assessments, she does the Addiction Severity Index and also the 10 RAS, which is a risk needs assessment. As it is, we are looking for high risk, high needs people in drug court. Those are the people that this program is created for. As Eric said, if your client is low risk, maybe has a misdemeanor and doesn't have a substance use disorder, you think it's more social, then you try to get another offer because they're not a client that will do well in our program. They don't need it. So once we have the assessment results, we're going to set, when you come in after we interview your client, we're going to get a court date for you to come back 2 days after the client gets assessed. So if they get assessed in jail on a Monday, your client's going to be set for that Wednesday. What's going to happen on that day is 2 of our counselors will talk to the person and go over the recommendation on the assessment. And we'll let them know what level of treatment is recommended for them and go over what that entails. And also one of our peer recovery specialists, who we have 3, Renwick, Brian and Lakeisha, one of them will talk to the person as well. And if you don't know what a peer recovery specialist is, it's someone, in our case, that has a lived experience with addiction and has been successful in treatment. I think everybody has well over 5 years of sobriety. That's a peer recovery specialist in our program. So that's the assessment, or that's 2 days after the assessment is when they'll be set on the docket. That's when that will happen. Then we're going to set the client for a discussion date where we discuss with the team and develop the treatment plan, what is recommended for this client, and get them set up for treatment. So on that date, if we say it's a go, then you can go forward with the paperwork. Now, if your client has a warrant from another jurisdiction or a case that's open on the NCIC that is a violent case, then those are things that you will need to work out. If it's on the NCIC, Marguerite can get her investigator to look into that for you. If your client is on probation and facing a violation of another jurisdiction, then you need to contact that jurisdiction and make sure they're not going to violate the client and throw them in jail, after we get them in our program. So those are things that you would have to work out. And normally, a person can get in the program in 14 days unless those other things happen and it takes you a while to get another case worked out or get a warrant taken care of. So I'm going to talk about some things that the program entails, and then Brian is going to go more in depth about what is involved in those treatments. Okay, number one, so one of the most important things is your client's going to report to drug court, Division 8, to see Judge Wilson. Initially, that will be weekly. So for the first 8 weeks, every client will come to see Judge Wilson weekly. Then we move to bi-weekly, and then when the client is ready, we move to monthly. So Judge Wilson, we go over every client's progress or sometimes lack of progress, drug screens with Judge Wilson prior to the clients coming to court. And then he talks to them individually, each person, for about 3 minutes about what is going on, what they need to do differently, or gives them encouragement, if they're doing well. We'll talk about incentives for people that are doing well later. A client will report to the treatment provider for treatment sessions each week. Initially, it'll be 3 times a week, and then it moves down. Your handout is a general guideline of what the program looks like. It is individualized, so some people will stay in a phase longer if they test positive or we feel they're not ready to move to the next phase. They will attend at least one self-help meeting per week, which is of their choice. It's NA, AA, CA, Smart Recovery. Also, they call the drug testing line or check in on the web every morning to see if they have to report for a screening. We give them the information about what hours the screening facility is open. They will get all that when they enter. Also, there are program fees of $75 per month. They do not pay fees while they're in residential. They don't pay fees if they are in sober living either. So we do have to collect fees, for several reasons. One, we feel it makes the person responsible, and they appreciate this chance at treatment more if they are vested in it. Also, we don't have access to treatment like the other courts. Our clients aren't eligible, for the VA, which, is at no cost to the client or the program. They're not set up like mental health court is with Alliance, where block grants take care of them. So those fees do help our program continue and give the person a vested interest. But also, let me say, if their case is in Division 8, they don't have any fines. So the fines on the case would have been more than what they will end up paying in drug court. If they're out of criminal court, that's a different story. They may have fines. Also, the client will will have visits with their case manager. We now can do this virtually with them, so they don't have to get transportation to 201 Poplar, they don't have to get off work early, or pay to take the bus. So those are based around the client's schedule as their treatment sessions are, so try to make it as convenient as possible for the clients. Treatment plans may also include inpatient treatment, placement to sober living, access to medically assisted treatment, which is Vivitrol, Suboxone. Occasionally we have someone on methadone, and access to mental health services. So we do make sure a client is connected with everything they need to be successful. We connect clients to Christ Community, or Alliance for Mental Health Issues, and also Church Health Center. The last thing I want to touch on is the statute that Eric talked about that redefines a violent offender to allow for, well, it's written as to allow for more offenders to be eligible for drug court. So the exceptions are those who use a firearm in their crime, were convicted of domestic assault, or caused death or great bodily harm. So that does include misdemeanor domestic assaults, unfortunately, and this was effective as of June 2021, so it's any convictions after that date. If it was prior to that date, we will still look at them. So if your client is arrested for domestic violence, you want to get them to amend that to assault, so they can enter the drug court if they're an appropriate candidate and have been given approval by Hagerman's team. So now I'm going to turn it over to Brian Owens so he can go into more detail about what our treatment plans entail.
Yeah, please. Hi, everybody. So I'm Brian. I'm the CPRS in the program. So drug court, like, what are we trying to end? It's a holistic approach to stopping the cycle. What cycle are we trying to stop? Well, you think, well, duh, addiction. Actually, no. What we're trying to do is stop the cycle of coming into 201 over and over again. The repeat offenders, right? That's what we're trying to stop. Sometimes we got to stop with addiction, or sometimes it's behavior modification. Like, there's a multitude of different things that we do in drug court. So again, recidivism. So 44% of people that are released out of prison out of a year are going to reoffend. So you're going to see them again. They're going to be your client all over again. Hi guys, see you again. It's like deja vu, right? They got the same case, same excuse, same everything. Wrong place, wrong time. They got the wrong person, right? So out of those people, also 68% will actually reoffend within the first 3 years, and then 77 up to the next 5 years. So as we see, like, 3/4 of the people are going to reoffend in the next 5 years. That's astounding numbers, right? Like, what can we do to stop this program, or stop this cycle? So here's what we can do. So I'm not going to talk about what we can do. First, I'm going to talk about our numbers. We've been in the program from 1997. So in over 5 years, we're talking about 77 without help. With us, we're able to knock it down to 25%. I know you don't want to lose clients and lose money, and it's going to cut into the bottom line, but come on now, right? So, joke, y'all. So, what is the Shelby County Drug Court? So the Shelby County Drug Court is a program to really just help people stop reoffending and stopping the cycle of addiction. And we've already talked about who is eligible, right? So Marguerite already talked about who is eligible. So we're looking for nonviolent offenders and anybody that committed a crime in Shelby County. So they can be in Barr, they can be in Collierville, they can be in other courts. And that's who's eligible. The key thing for me is nonviolent offenders. That's the thing for us. So the next thing is like, well, how do I know if my client has a drug problem? There's this simple thing called a cage questionnaire. It's super easy. It's like, have you ever tried to cut down on your usage? Some of them are going to say no. Why would I? Right? Do you get annoyed when people talk about it? Talk about you stopping? Does that annoy you? Have you ever felt guilty because you're not there with your kids? Have you ever tried an eye-opener? I know our weed heads, first thing they wake up in the morning is smoking, right? Blaze it up. They got a hot and ready by bed, and they're smoking. So here's the question I would really ask. So you got your people that pop positive on their drug screen for probation, and you're like, man, you're getting drug tested. And what do they say? I know. Like, man, you gotta stop. And they say, I know. What they're really saying right there is, you don't understand. I know I'm not supposed to be doing this, but I'm doing it anyway. That's what they're saying. You got to hear what they're really saying. They're saying, I know I shouldn't be doing this, but I'm doing it anyway. Listen to the cues. Sometimes listen to what people are saying is listen to what they're not saying, right? So what makes our program effective? First, we got Judge Wilson. He's the first black male recovery judge in the state of Tennessee. We do weekly monitoring. Interactions with Judge. Whenever I say interactions with Judge, I don't mean negative interactions. This is a month ago, one of our people was in a play, and he went to the play to go see him. That kind of interaction, not the negative interactions. We're talking about positive interactions where we go out to the community and we meet them in the community away from the court. Frequent drug testing. They're getting drug tested a lot. Not too much, not overwhelming, but come on, we got to keep an eye on them. We have case managers. We have a lot of case managers, and each case manager deals with a specific population. Maybe they deal with trauma. Maybe they deal with people that have criminal court cases. You know, everybody's specialized. And then the other thing is we have this peer counseling that Angela talked about, right? And the other thing that makes drug court really effective is we are innovative. We are willing to change. We adopt with the time. And let me tell you how we adopt with the time. Because drug court hires people in recovery. So, Angela alluded to this, like, I'm in recovery, right? So, over 14 years ago, well, let me start off. So, I was raised in poverty, right? I was raised with poverty. First time I committed a crime, I was 13 years old. My brother taught me how to kick in a door. We were going in to get cigarettes, guns, and alcohol. My dad had me smoking weed at 6. Why? Because I was too much of a handful for him. So, not only did I have a genetic predisposition, I grew to this, right? Social economics standards. So, next thing I know, I'm homeless. One of Memphis's many deadbeat dads. Poverty, unemployed, unemployable. Right? So I pick up a heroin charge. Not heroin charge, I'm sorry. Somebody turned CI on me, consummate informant, and had me sell morphine to undercover. And I'd just been out of jail for 3 days. And then here comes cops knocking on the door on a secret indictment. So instead of getting what I deserved, which was 4.3 years, I got this thing called justice in the form of drug court. Now, what would be nice is for me to say, whenever they made me the offer of drug court, first they didn't want to let me into drug court, right? Because I'm high risk. I'm a drug seller. This great man right here that y'all like went, woo! They didn't want me in drug court, and he went and argued and argued and argued for me. This lady right here, Angela, is that rude? But, so, she argued for me to get justice. This is the kind of people that work in this courtroom. So instead of getting what I deserved in 4.3 years, I got justice in the form of drug treatment. And I would like to say I wanted drug treatment. But you know my deciding factor to take drug court? I didn't want to do 4.3 years. That was a deciding factor. It was either bad choice or really bad choice, right? So they put me in drug court, and I got sent to rehab, and then after that I went to a halfway house because I didn't have from homeless. And as the things happened, I ended up graduating drug court. Today, I'm a homeowner. Instead of being homeless, I'm a homeowner. In fact, next week I'm selling my house. Instead of not having a car, I have a car that's legal. If I hit y'all, I got insurance. Right? Isn't that nice? I've been working for the courts for 10 years now. They took a risk on hiring me. without a college degree. I was going to college when they hired me. Barely graduated high school. I graduated with my bachelor's in 2016, graduated with my master's in 2018, and I just graduated again with another bachelor's in nursing just this past year, or last year. After saying all these amazing things, my proudest moment, the day that I got custody of my son. After all those amazing things, my proudest moment still today is whenever I got custody of him. Instead of him going through the cycle of addiction, I got to teach him how to be a man. Instead of me worrying about him being the way I was, he's the way I am. So whenever you enter somebody in a drug court, think about the things that you're touching. You're not just touching an individual, you're touching an individual's family. So that's the reason why I do that whole little spiel about people in recovery and like how powerful this program is. In drug court, we identify barriers. So what's a barrier? They don't have housing. You're going to have a lot of people talking about, yeah, I got a place I live. They don't have a place. They're living at their grandma's, they're living at the aunt's, they're bouncing, they're couch surfing. Let's be for real, like what we're really dealing with down here. They're couch surfing. They say they have a house, but they don't have a house. We're able to put them in safe, sober living environment. They don't have transportation. We help them out with transportation. And the other thing is like, how can I get a job? I got a felony. Guess what? We help out with employment too. We got a guy specifically that nonstop gets people jobs. The thing that we also talk about is sanctions, right? So this is the big bad word, sanctions. Like what happens when our clients mess up? Because the truth of the matter is they're going to mess up. So what's a sanction? It can be a one-on-one conversation with judge, which happens frequently. This is usually probably our most used resource right here. Just a good one-on-one conversation with judge, and it's not going to go good. A conversation with someone like me, a peer, more group therapy, community service. Maybe they need a change of environment. Or write a letter of apology or an essay assignment. What I want to stress is jail is the last resort. We don't start off with jail. That's when everything else has failed. We talked about sanctions, what about incentives? Yes, there's positive things too. Verbal praise. Some of these people have never had somebody praise on them. All of a sudden, for the first time in their life, I was hear somebody say, I'm proud of you. They have less court visits, right? They have travel privileges. They're like, I want to go to Nashville to go see, a show. Go see the Vols play. Okay. Gift cards. We recognize them as a group leader. Written accommodations. And the last thing is ambassadorship. They are ambassadors. They represent us. We have several different kind of programs in drug court. We have inpatient, frontline, marijuana track, mental health, trauma, mother's program, and DUI. I'm going to explain them a little bit, and I'm going to try to go fast. So inpatient, they stay in the treatment facility for 28 days. While in the facility, they have programming the whole time. They wake up at a certain hour, they go for breakfast, they do meditation, they do group therapy, and it's just nonstop. It's a filled day of activities. After they do inpatient, they do what's called IOP. So IOP is just that, it's intensive outpatient. It can be anywhere from 12 months to 18 months. And it starts off pretty aggressive. It's 3 days a week they have to go to class at 3 hours at a time. They have to go to one outside meeting a week, which is an AA meeting. They do random drug screens. They pay for fees. We've already talked about this, so I'm not going to go into depth. And then from there, as they progress, we let down on the restrictions, right? We have the frontline program. So the frontline program is pretty amazing. So it has to be a black male between the ages of 18 to 34, and this is where we do a lot of behavior modification. Maybe this is like more lifestyle. And like one of our counselors, instead of calling it lifestyle choices, he calls it death style, which I like. You know, it's death style that's killing them. So the clients they move up the phase and have to do what's called MRT, and they do MRT group, and it lasts about an hour as a program. And they're around other black men that are supporting them, and it's about a group conscious, right? And they start seeing other men that look just like them, sound just like them, moving forward, and they're like, you know what? I think I can do that. I think I can do that. We have the marijuana track. So the marijuana track is 9 months. The one thing I want to stress about the marijuana track, you're like, I want my guy to do the marijuana track. So it's not that simple, right? They can't test positive for anything other than marijuana to stay in it, right? So let's just, the track is faster, but if they test positive for opiates, they just went into the 12-month program. So we have a mental health program, which is really just IOP, but along with it, we have a treatment provider that actually assesses them and their mental health needs, and then we link them up with mental health services, medication, and everything. If they can't pay for medication, we will help supplement that medication and pay for it. We have trauma groups, so a lot of people go through trauma, and they have lived trauma from life. It's the same IOP program, but also they do an additional trauma group. We have the mother's program, so this is a woman that comes in and she's pregnant, right? She's pregnant with the baby, and typically they're fentanyl users, not always, but you have your pregnant woman, so all of a sudden we're not just treating one person, we're treating a unit, right? Because there's a human being inside her. And they go into our program and they live in the housing and they stay there until 6 months following the birth, because we're going to track their parenting skills and everything else. And then we have the DUI program. So Eric talked about our DUI program. It's the people that have second offense DUIs. And now theirs is a little bit more rigid. It's only 12 months, but unlike the others where as they progress through the program, they'll end up not going to any classes, this group will come and they will do what's called phase 2. So for 2 months, they'll do 3 classes a week, and then after that, they'll forever do 2 classes a week. We hang out with the clients. We do events with the clients. So not only are we doing classes, we throw holiday parties where we dance. You can see a picture of us dancing. Here's one of our wonderful counselors, Katrina, you know, getting jiggy with it, with the clients. And, you know, that's the thing, is like we hang out with them. We talk to them, and it's not in the courtroom. So it's really different. Here's another picture of us just hanging out with the clients for a holiday party. And the next thing I want to talk about is we also have fundraisers for our events, for our program. So not everything's covered by the state, and therefore we have to raise money for us. So we have this thing called the Shelby County Drug Court Foundation. If you missed our holiday party, you missed out. We had a blast. Everybody was dancing, cutting up. It was back in December, and here's a picture of us all hanging out as a group. And the last thing I want to close with is, if you could possibly, even if you don't put somebody in our program, please follow us on Facebook, like us on Facebook, look at our events, share our events, just so we can get the word out into the community that there's other resources than incarcerating people. And with that, thank you all so much, and I'm going to turn it back over to Eric.
At this point, since this is a CLE, I thought we should talk a little bit about law. And I've selected 4 cases to discuss. They are in your handout. How much do we have, Kathy? 25 minutes?
We have 34 minutes.
34, okay.
34.
All right. Okay. First case is Commonwealth versus Eldred. It's a case out of Massachusetts, from the Massachusetts Supreme Court. So it's certainly not controlling for our jurisdiction, but I thought it was interesting just insofar as it talks about the disease of substance use disorder, and the client in Eldred tries to mount that as a defense at a violation of probation and tries to use it as a basis for modifying a probation agreement he had already agreed to. So the client in Eldred is a woman who's charged with larceny. That's what they call it in Massachusetts. She had stolen jewelry in the amount of over $250 from some clients. She was a dog walker, so she had access to people's houses. She was getting their dogs, walking them, and she had a bad heroin addiction. So Miss Eldred wound up settling her case, her larceny case, with a year's term of probation, and 3 of the conditions of probation were: 1 is to remain drug-free, so abstinence; 2 was random drug screens, and then 3 were 3 counseling sessions a week. So it wasn't drug court, but it was a fairly intensive probationary arrangement, because you had random and frequent drug screens and 3 counseling sessions a week. So that is what Ms. Eldred embarked on. She had been she'd been on probation less than a month when she had a positive screen for fentanyl. And this was back in 2000, I think it was a 2018 case. So let's think about Ms. Eldred and her attempt to use substance use disorder to change her probationary requirements. One of the things that is important to know about this case is she did not, before she agreed to the probation, back when she was in the trial court, pleading and agreeing to probation and being probated, she did not assert her substance use disorder at that point in time. And that's something I think the court had a problem with. She didn't assert her substance use disorder until she violated her probation. And when the judge ultimately locked her up for 10 days and then ordered her into inpatient treatment. So it was a fairly brief incarceration and then mandatory inpatient treatment. It was at that point that Ms. Eldred wanted to, she filed a motion to vacate the condition of probation requiring her to remain drug-free and take drug screens. So, when the judge locked her up initially on a probation violation, he or she, I'm not sure what the trial court judge, but that judge did make a finding of fact that Ms. Eldred was a fentanyl addict. She had just used, she had no family support. She had initially rejected, apparently, according to the trial court, an offer of inpatient treatment when her violation arose. And another interesting fact that the judge cited was the 3-day Labor Day holiday was about to begin. So those were all factors that that judge took into consideration when locking Ms. Eldred up for 10 days, violating her probation, and requiring her to then, upon release, go into inpatient treatment. Ms. Eldred never denied that she used drugs. She admitted she used drugs, but she denied that she violated her probation. She argued that she had substance use disorder, which rendered her incapable of remaining drug-free. Her argument is she was medically incapable of remaining drug-free. Thus, her use could not constitute a willful violation of her probation. According to the opinion, she submitted several affidavits, I guess from treatment professionals or doctors, in support of her claim that she had substance use disorder. But she did not have any experts come testify at her probation hearing, so there's no testimony from experts that could be cross-examined. There were simply affidavits. I think the court took a bit of a dim view of that also. So she filed her motion to vacate the condition of probation required her to remain drug-free. That was denied by the trial court, and she was ordered to go to inpatient treatment. So ultimately, I'm not sure exactly the procedure of Massachusetts state law, but ultimately a certified question of law arose from this case that was forwarded up to the Massachusetts Supreme Court, and the certified question of law asked two questions. One was, can probation require abstinence in a person who suffers from substance use disorder? And the other question is, can a judge revoke someone's probation and hold them in custody for violating abstinence if they suffer from substance use disorder? So, and there's some language in, if you want to read the opinion about the propriety of the violation of probation being in front of the Supreme Court on the certified question of law. I'm not sure it's procedurally up there correctly that the Supreme Court of that state talks about their general superintendent's powers, which I guess is they can take what they want to take to review if it's a policy issue. But the court, this was the court's holding. This was the Supreme Court's holding about this question of substance use as a defense, substance use disorder as a defense. And this was how they addressed her desire to vacate portions of her probation agreement. The court held that judges have great latitude in imposing conditions of probation. And those conditions are enforceable as long as they are reasonably related to goals of sentencing and probation. So, I'm quite sure that the appellate courts of this state would also say that judges have great latitude in imposing conditions of probation. But this court found that among other probation goals are one goal is to promote public safety, and another goal of probation is to ensure offender accountability. So this court felt like the judges had the latitude to impose conditions that they were related to the goals of promoting public safety and ensuring offender accountability. Those were the two probationary goals that the court cited. The court did hold, or I guess they held, that drug and alcohol testing constitutes search and seizure, but nonetheless it is permissible as long as reasonably related to probationary goals. So there's a lot of talk in the Eldred case about what should be the goal of probation, and that court found that abstinence furthered the rehabilitative goal of probation. I think probably most courts would find that one goal of probation in most cases is rehabilitation, to rehabilitate the client or the offender. And this court felt that abstinence furthered the rehabilitative goal of probation by facilitating treatment for the addiction. The court also found that the abstinence furthered the goal of protecting the community, because Ms. Eldred's behavior of taking jewelry out of dog owners' homes was motivated by her drug addiction. So the court found that the probationary goals of both rehabilitating Ms. Eldred and protecting the community by helping her deal with her issue, her addiction issue, and hopefully preventing further thefts, that the abstinence requirement was reasonably related to those goals. They also felt like she did wait until she violated to raise the issue that, I have substance use disorder. And they also did not like the fact that she didn't have a live expert who was subject to cross-examination to testify about the science surrounding substance use disorder. So, how should we apply this in Tennessee? Sometimes we don't have a lot to argue. Substance use disorder, I don't think I haven't found any cases in Tennessee where that has been the issue. So maybe you can make some law and argue that, you know, your client should not be violated because they have substance use disorder. Get a real live expert, don't bring affidavits though. And be sure to assert that in a timely manner. Does anybody have any thoughts about the Eldred case and the notion of substance use disorder being used as a basis to modify probation or basically defend yourself against a probation violation? Yes, Stephanie?
Substance use disorder in the, I don't know if I'm saying this right, in the DSM-5?
I think it is. In the next, I'll tell you the next case I'm talking about. There's a federal opinion where it is someone with substance use disorder is the federal court held that they should be protected by the ADA, the Americans with Disability Act. So yeah, I think substance use disorder is definitely a scientifically accepted disease. I guess the question is, does it rise to the level of, I don't know, vacating probation requirements and defending, does it rise to the level of being a defense against a probation violation? The next case is a case called Pesci versus Coppinger, and Mr. Pesci, in this case, is suing Coppinger. Coppinger was the sheriff, and this, interestingly, comes also from Massachusetts. This is a federal district case where Mr. Pesci sought injunctive relief against the sheriff of Essex County, Massachusetts. And a little bit about Mr. Pesci. He was a 32-year-old man at the time, this is a 2018 case, who was battling opioid use dependence. So he was battling an opioid use disorder, like a substance use disorder. He was terribly addicted to opiates. He lost his job, he lost custody of his son, he had lost his home, he was essentially homeless. He had at least 6 times overdosed on opiates and had to be Narcan. So he was in the throes of a very wicked addiction he was suffering from greatly. He had been through 4 detox programs, 4 attempts at rehabilitation, and those 4 programs all used buprenorphine, which is Suboxone, and naltrexone, which is Vivitrol. So he had been through 4 attempts at medically assisted treatment using Suboxone and Vivitrol. He had failed at all of those attempts. So he started going to a mental health facility or a rehab facility, I guess, where a doctor prescribed him methadone. Methadone is a different, opiate replacement therapy. It is different from Suboxone. And this doctor did testify at the hearing on the injunctive relief, and she testified that there's research that a lot of people are not, there are some people that for whom Suboxone and Vivitrol do not work, but methadone does work. And so she testified that Mr. Pesci needed methadone. And the reason he was suing the sheriff of Essex County was because of some legal issues that I'll explain in just a moment. A incarceration period was probably imminent for Mr. Pesci, and he was very concerned and truly terrified about having to be off methadone for what would probably be about a 60-day incarceration period. Mr. Pesci had, and let me just say this, after the 4 rehab attempts did not work with the Vivitrol and the Suboxone, after he got on methadone, he had been clean and sober for 2 years in active recovery. Before that recovery period, when he was still in the throes of addiction, unfortunately, Mr. Pesci had been arrested for DUI, okay? And he had been probated on that DUI with a 60-day suspended sentence. And as fate would have it, and Mr. Pesci's bad luck would have it, one day while on his way to the methadone clinic, he got pulled over. He was driving on a suspended license from the DUI that he got before he got sober. So they arrested him for driving on a suspended license. And in the state of Massachusetts, the license is suspended for a DUI. You have a minimum 60-day sentence for driving on a suspended license. This unfortunately also triggered a violation of his probation, and he was looking at potentially serving 2 60-day sentences, both for the driving on suspended and for the DUI. And he was very worried, and his doctor was very worried about him being without methadone for 60 days. The doctor came and testified at this injunction hearing that involuntary withdrawal of methadone for someone like Mr. Pesci, who had been on it for so long, would cause severe and needless suffering, jeopardizing his long-term recovery. And she also testified that denying medically necessary methadone treatment will place Mr. Pesci at a high risk of both overdose and death, because if he was going to be locked up in a county workhouse it was called the Essex County House of Detention at Middleton. If he was going to be locked up for 60 days in the House of Detention with no methadone, he would undoubtedly experience extreme and acute withdrawals, be very sick. His tolerance for opiates would be greatly reduced, and his recovery would be so challenged that the doctor felt like the first thing he would do after he was released would be to go score opiates and probably die, because he has no tolerance, and in the very least, she said the probability of overdose was high and or death. So, what we had in response from the sheriff was that the Essex County House of Detention does force withdrawal, but under medical supervision. Their defense was that they would provide Mr. Pesci with substance abuse therapy, educational programming, and reentry services once he got out, aftercare in the community once he got out. And while he was in custody, they would give him ibuprofen, Imodium, Zofran for nausea, Maalox for indigestion, and clonidine for anxiety. But no Suboxone, no methadone, no withdrawal. They just treated medically the withdrawals. He and his doctor felt like that was woefully insufficient. So he sought injunctive relief requiring access to methadone while incarcerated. And the court, the federal district court, held that Mr. Pesci, who suffered from an opiate use disorder, was a qualified individual with disabilities under the Americans with Disabilities, the ADA, the Americans with Disabilities Act. The court held that medical decisions that rest on stereotypes about the disabled rather than an individualized inquiry into the patient's condition should be considered discriminatory. The court also held that the jail's primary objective, and I think this is the objective of most law enforcement agencies, is to promote public safety. They did not get it. The court also analyzed this under the Eighth Amendment as far as cruel and unusual punishment would go, and the court found that refusal to administer methadone in this case constitutes deliberate indifference to his medical condition, puts him in danger of irreparable harm, and creates a high risk of overdose and death upon his release if not treated during incarceration. So this is a case that has been discussed at drug court conferences I've been to before. There's another case very similar to it from Maine. So these are federal courts. They're granting injunctive relief, basically a restraining order preventing a jail from not giving a client opiate replacement therapy. But this is a federal district court, it's a trial court, and they granted the temporary injunctive relief. I suppose Mr. Pesci got his methadone, but outside of the two cases, this case in Massachusetts and that case in Maine, I read a law review article, looked at a law review article yesterday, trying to prepare for this seminar, and it came out last year, and as of the publishing of that, there had been no other cases where courts had ordered, through temporary injunctive relief, jails or prisons to administer opioid replacement therapy. I know this jurisdiction in this jail, if a client is on Suboxone or methadone, no, this jail does not give it to them. It does not require that it be given to them unless the person is pregnant.
I'm sorry, that was just my meditation time.
So, I mean, I think this is a very compelling argument. I think a lot of the language in the case is something that we should argue to judges if they're trying to revoke a client's probation and the client is on methadone or on Suboxone or even on Vivitrol. Does anyone have any thoughts about this Pesci case? Yes.
I attended the Tennessee Recovery Court Professionals conference in December, and one of the presentations was very eye-opening. They actually showed the brain of a person who is either a drug user or an alcohol user. So they showed like the brain of a normal person with normal functioning, and then they showed an addict or an alcoholic, and when they were sober, there was no brain activity. And when they were on the drug or intoxicated, their brain looks identical to a normal person functioning. So they're literally dependent upon it. Probably the most eye-opening thing for me was when he said that on average, it takes a minimum of 2 years for an addict's brain to go back to normal after being sober completely for that period of time. So if you imagine, that's why when people go into recovery for a few months and we wonder why they're relapsing, like physiologically, they can't control themselves. They can't help it. They need it. If these medications are helping them get past that point so that we can get to the other side of things, I think that's a very compelling argument for making sure they're continuing those treatments, because we know there are definitely, unfortunately, drugs available to them in the jails. And I think we should try to do everything that we can to help them stay within their recovery so that they can hopefully get to the other side.
Yes, I agree with that. Thank you for that comment. Anybody else? Good. The last two cases are not quite as complicated, and just when you started getting annoyed that I'm not talking about Tennessee cases, I have one from Tennessee. And this is the case. The case is a funny one. It's not funny at all, but it is something that I think the drug court team can really relate to. One thing we love about Judge Wilson is that he's very collaborative. He's a very collaborative judge, but I don't think he would ever abdicate his power completely to the drug court team like this judge in Warren County, McMinnville, Judge Larry B. Stanley did. This is a case involving Charles Hobson Stewart. That is the defendant here. He was convicted of 4 counts of possession of cocaine with intent to deliver up in Warren County. He got 9 years on each count, concurrent, thank God, but he was placed in the drug court. Mr. Hobson had some problems while he was in the drug, Mr. Stewart had some problems while he was in the drug court, including being charged with stalking, failing to maintain full-time employment, and not being truthful with the drug court coordinator. So it came down to termination. It was a situation where I guess the state was moving to terminate him from the drug court program. And this Judge Stanley had a sentencing hearing, and numerous family members and friends of Mr. Stewart's came and testified. He testified about his remarkable progress he had made in the drug court, about his efforts to find a job in the face of some severe physical limitations. I'm not sure what those were, about his good character, and about their support for him. And at the conclusion of the hearing, this Judge Stanley in McMinnville asked members of the drug court team who had been present during the hearing to deliberate and submit a written recommendation to the court at a later date. He wanted it on Thursday, February 28th. He wants the drug court to meet without the judge and present the recommendation to the court. The team can he said the team can recommend that Mr. Stewart be terminated from drug court to serve his original sentence, or they could, recommend that he stay in the drug court. To quote the judge, he said that he wants the drug court team, what I want you to do by the end of business on Thursday, I would like for you to give me a written recommendation from the other members of the drug court team. I'm not going to participate in that. I have no thoughts or opinions on what you should do. You should decide what the defendant, if the defendant should come back with no sanctions whatsoever, or if he should be revoked and dismissed from the program, or anything in between. I do not care what your opinion is. I trust your judgment. The drug court team said sentence him to his 9 years, and the judge did it. So he filed an appeal. And the court in the Stewart case ruled that in Tennessee, the neutral and detached hearing body is statutorily prescribed to be the trial judge. The statute does not give the trial judge the authority to consult outside entities or persons in making this determination, or to delegate the decision-making authority to another entity or person other than another trial judge. Based upon the statute, we hold that this trial judge violated the defendant's due process protections in allowing the drug court team to deliberate and make a recommendation to the court about the disposition of a matter that was statutorily vested in the trial judge's authority. Further, this case reflects that the trial judge not only received the recommendation from the drug court team, but he delegated the decision-making authority to the team, telling them the trial court instructed the drug court team that he has no thoughts or opinions on what you should do. So, this case, stands for the proposition that the judge should make the decision at a sentencing hearing and not defer to the drug court team.
Well, as I said at the beginning, I always make the decision.
How much more time do we need to go to Kathy?
3 minutes today, second.
Okay. This is a real brief decision called Limke from the state of Washington. This is a wild decision. Okay, so what we have here is a client who was also being terminated from drug court. His lawyer had wanted the judge to consider something in Washington called a DOSA, which is a drug offender sentencing alternative. So it is a downward departure from whatever the person is looking at for violating his or her probation. And the law in Washington is that a client can ask for that, and the judge has to consider it. This judge summarily rejected the client's request for a DOSA, and the client appealed something that would not normally be appealable, but given the way that this judge had treated the client over the course of his drug court program, I think the appellate court decided that they should review this situation. This judge had taken this client into drug court on 2 counts of possession of meth and 1 count of shoplifting. He was looking at 24 months if he was terminated, with 12 more months of community corrections. He did go to progress hearings in front of the judge, and at these progress hearings, the judge told him that, well, you can read the summary. He called him an effing addict, a liar, a thief, a manipulator, just a criminal. That's all you are. You're just a criminal. He stated that the odds say you're going to die in prison. So the judge was constantly belittling this client using extreme profanity. He called the client had a shoulder injury he sustained while doing community service the judge had ordered him to do, and the judge said, you can get out of here with that shoulder bullshit. He said all this on the record from the bench, including 2 tirades in which he repeatedly used the F word. So,
hey, Eric, did he ask him, did he tell him that he wasn't Burger King?
That's not in the opinion. So, the High Court reversed and remanded for a resentencing before a different judge. Is that about us for our time, right?
Anybody got a quick question? Maybe? No? Okay, I think you said it.
Should I have informed you?
Okay, that's